Thank you all. Okay, I want to start off with a question for all three of you. All three of you have touched in your presentations on the intent requirement or lack thereof, and how under current law there's a knowledge requirement that people have to know that it's a designated group or that the group's activities include unlawful conduct, but not a specific intent requirement. And I'd like to ask if Steve, well, if all the panelists would touch on if that change were to be made in the law, so if there were a specific intent requirement, how as a legal matter, particularly for Steve, and as a practical matter, particularly for Lisa, and Shane, you can pick or do both, that would change things.
Well, I guess I'll take what I think might be the easier part of that question, which is the legal answer. I mean, I think legally it would actually have a very significant impact from the government's perspective on what the burden of proof would be in cases brought under the statute. I leave it to all of you to decide whether it's a positive or a negative impact, but I think it would be an impact because rather than merely demonstrating that individual defendants were on notice and were aware of the particular activities that they were supporting, you would actually have to show, if you were the government, that the purpose of the support was to further these activities. And I think it's not hard to understand why that is a very heightened showing compared to the current status of the law, and why it would make these cases significantly harder to prove and significantly harder to make. And I think in that regard, you know, it's important pointing out something that Shane mentioned that I neglected to mention in my opening. The material support statute, part of why it is so important is because it really has become the anti-terror weapon of choice for federal prosecutors after September 11th. You know, most terrorism prosecutions in the civilian courts since September 11th have been brought at least partially under the material support statute for a very obvious reason. It is a lot easier to prove that a terrorism suspect provided material support to a FTO, to one of these designated groups, than that they actually were directly involved in acts of terrorism. And so I think adding the specific intent requirement would change that calculus quite substantially, whether for better or for worse.
Right, and you know the fact that it's not there now still hasn't prevented the government from having great difficulty in these prosecutions, again, because it is the weapon of choice. And on this sort of Ashcroft model of you arrest someone when you haven't gathered all the evidence and throw a news conference, it sometimes becomes difficult to figure out what exactly you think people have done. I mean, you see that with the sort of Lackawanna 6 case, but even folks like John Walker Lind were charged with material support. I mean, I guess, I would just draw everyone's attention back to those Communist Party cases. When you think about what was at stake, the U.S. involved with the Cold War, sort of an existential threat, much more so than I think, you can realistically argue in our sort of, current sort of global war on terror. In Scales, the case from the early 60s, the court went on at length about how, Scales was a member of the Communist Party, how they had all these international links, how they were involved in terrorism. And yet, that wasn't enough to hold him liable without specific intent to further those goals of the sort of larger Communist Party. The De Jong, a case from the 1930s, the Supreme Court said that De Jong had gone to sort of a Communist Party rally. He was a member, and that he acted under party auspices in speaking and encouraging others to join the party, and found all those other sort of nefarious things about the party's goals writ large, but found that De Jong himself had only advocated peaceful ends. So this is not the kind of standard that has been absent from U.S. criminal law for a long time. And then the most recent sort of significant case, NAACP versus Claiborne Hardware, a case that was decided in 1982 but stretches way back to the late 60s, about sort of violent kind of enforcement, essentially, of economic sort of boycotts in the Deep South. Again, the court said, well, some NAACP leaders may have threatened violence if you didn't comply with the boycott, but the court said to be held liable, you had to engage in or directly incite that illegal violence. So the Supreme Court has never criminalized in a blanket manner, a sort of political speech that seeks to further only lawful, nonviolent activity. So this, it's not something that's unheard of. In fact, to find the opposite direction, I think, would really require the court to sort of toss aside a huge number of precedents stretching back over the last century. And I just wanted to say something about Lisa's first sort of question, which is it illegal to listen to the Taliban? Well, it turns out that on pages 60 and 61 of the government's first brief in this case at the Supreme Court level, filed on December 22nd, they do clarify that. They say you can peaceably assemble with members of these groups. So it's good to know that after 12 years.
Thank you for that clarification. Just on the practical level, let me talk about the examples in Palestine, because there are many nonprofit community development organizations working in Hamas-controlled areas, basically, that are not able to get funding from the U.S. to do education training, democracy training, good governance work with civilians who have some association with Hamas, which it's very difficult to find anybody who doesn't have connection with Hamas in some of these regions. And so again, it's counterproductive to U.S. interests in these regions to promote democracy, to promote good governance, and education, and et cetera, human rights training. So all of these things are actually not happening because of this law being unclear about whether it is criminal to provide human rights training or democracy training to people that may have association with Hamas.
Okay, I want to ask each of you a separate question now before we open it up to Q&A with the audience. Starting with Steve, as our constitutional law expert and Supreme Court watcher on the panel, I'm wondering if you would give us any kind of prediction on how you think this case may come out.
I actually am usually not the least bit shy about predicting how the Supreme Court is going to rule in cases, and I like to say I'm actually usually pretty accurate. I have no idea, and let me just sort of try to say why I have no idea, because I think that might help actually answer the question. The way that this case is sold, I think, in the briefs by both parties, is as a case with monumental implications. The government sells this as a case that goes to their ability to treat terrorism as a crime and to use the criminal courts to prosecute individuals who might even be loosely affiliated with al-Qaeda and other terrorist groups. A government lawyer, I think in the Ninth Circuit, once said the whole purpose of this regime is to make these organizations radioactive. And that, that is the driving prerogative, and the Ninth Circuit's decision risks that ability on the government's part. In the other direction, you have Shane and his colleagues, I think, rightfully suggesting that the implications in the other direction are just as extreme, because it goes to the heart of the First Amendment and the significance of protecting unpopular speech during times of crisis, right? What Anthony Lewis says, freedom for the thought that we hate, right, and not just freedom for the thought that we like. If you take seriously both extremes, and if you agree that both are concerning implications and concerning potential effects of this case, then I think there will be an enormous amount of pressure on the court to decide this case narrowly and to actually avoid, as best as possible, going all the way in one direction or the other. And the irony is that the easiest way for the court to decide it narrowly may simply be to affirm. Right, to actually agree with the Ninth Circuit on the 3.5 provisions that are unconstitutionally vague, agree that the other provision and a half are fine, and that the specific intent, or the knowledge requirement added by the IRTPA ameliorates the guilt by association concerns. I'm not saying that is the right result, but I think that would be the way that the court could resolve this case on the narrowest grounds and by sort of reaching the smallest number of huge, potentially massively significant constitutional questions. And if they go that route, I don't think it would be 5-4. I think it could very well be unanimous, or at least 7-2 or 8-1. If they go beyond that, though, I think it's going to be quite a mess.
Okay, Shane. We've emphasized here that the question before the court is only a small part of what's at issue with the material support statute and the problems that peacebuilding groups and human rights groups have found. If you could just give a brief overview, if the court were to rule in your favor, of what legislative reform you might still be seeking for the statute.
Right. Well, You know, as Steve said, the court could very well, you know, sort of affirm what the Ninth Circuit, you know, has done here, which it has done repeatedly since 2000 on the vagueness front. You know, in which case, you know, we'd be seeking, you know, something legislatively that reaffirms that principle from the Communist Party cases about vicarious liability, how you can't hold someone liable without, if they don't have specific intent to further the illegal ends